5 words. That's all it comes down to. 5 words written in 1868, subject to the jurisdiction thereof. And whether John Sauer could convince 9 justices to read them differently than any court in American history ever had. While the President of the United States watched from the front row. By the end of this video, you'll understand exactly what happened in that marble chamber on April 1st, 2026. Why it mattered, what Sauer was up against, and what the answer could mean for hundreds of thousands of children born on American soil. The third piece? What actually hangs in the balance? It's bigger than the legal argument, bigger than any single case. All right, let's get into it. John Sauer is not a household name, but inside the Supreme Court, the man at the government's lectern carries a specific kind of weight. He's the 49th Solicitor General of the United States, sometimes called the 10th Justice. Not because he has a vote, but because when he speaks, the justices listen differently. He represents the institutional voice of the country itself. Every administration, both parties, for generations. That lectern is where continuity speaks. On April 1st, 2026, Sauer used it to argue for rupture. He came in with credentials that made the room take him seriously. Former clerk to Justice Antonin Scalia, the godfather of originalism, the idea that the Constitution means what it meant when it was written. Missouri Solicitor General, and most recently, the lawyer who won Trump's presidential immunity case. An argument many legal observers considered nearly impossible before Sauer made it stick. His reputation walking in, the man who already pulled off one constitutional miracle for this president. But this morning carried a detail no oral argument in American history had ever had. Donald Trump, the sitting president, the man who signed the order Sauer was defending, the man who nominated several of the justices Sauer was addressing, was physically in the room. Front row. The first sitting president ever to attend Supreme Court oral arguments. Neck craning. Whispers. Attorney General Pam Bondi beside him. Commerce Secretary Howard Lutnick. And in one of those details too cinematic for fiction, actor Robert De Niro somewhere in the guest seats. The justices were in front of Sauer. The president was behind him. Neither audience wanted the same thing, and the marble was cold to the touch. Here's what Sauer was defending. On January 20th, 2025, hours after his second inauguration, Trump signed Executive Order 14160, titled Protecting the Meaning and Value of American Citizenship. The order declared that children born in the United States are not automatically citizens if their mother was unlawfully present, or here only temporarily, and their father was neither a citizen nor a permanent resident. For children born after February 19, 2025, federal agencies were directed to stop recognizing citizenship in those cases. 3 days later, a federal judge in Seattle blocked it. His word choice was deliberate. Not arguably unconstitutional, not likely unconstitutional, blatantly unconstitutional. A second judge followed 2 weeks after that, calling citizenship a most precious right. Courts in Boston, New York, Maryland. Every single federal court that reviewed the order said no. Not one had accepted the administration's theory. Sauer walked into the Supreme Court not as someone splitting judges. He was the side that had been losing everywhere, asking the highest court in the country to be the first to say yes. His argument was genuinely rooted in history. That's what makes this more than a political story. The 14th Amendment was ratified in 1868, written to grant citizenship to formerly enslaved people and their children. Sauer's position, the phrase, subject to the jurisdiction thereof, was never meant to create automatic birthright citizenship for anyone physically present on U.S. soil. People here illegally are evading jurisdiction, not submitting to it. People here temporarily have only a passing connection. The clause, he argued, requires something deeper. allegiance, domicile, a real settled relationship with the country. Now here's where it gets interesting, and where the room started to turn. The wall Sauer had to climb is called United States v. Wong Kim Ark, decided in 1898. A man named Wong Kim Ark, born in San Francisco to Chinese parents, held to be a US citizen under the 14th Amendment. The court's reasoning was broad. Birthright citizenship flows from the ancient English common law principle of being born on the soil. Every lower court had cited it. Sauer tried to find a crack. The word domicile appears roughly 20 times in the opinion, and Wong's parents were lawfully and permanently settled in the United States. Maybe, Sauer argued, the case doesn't automatically cover people here illegally or temporarily. Chief Justice Roberts heard that. He noted the 20 appearances of domicile. But when Sauer argued that modern realities, mass migration, international air travel, birth tourism, required a new reading of the clause, Roberts replied with 8 words that became the hearing's defining line. It's a new world. It's the same Constitution. Justice Brett Kavanaugh, a Trump appointee, suggested the court could resolve the whole thing with a short opinion, saying Wong Kim Ark controls and Trump's order is unconstitutional. Justice Neil Gorsuch, another Trump nominee, warned Sauer, "I'm not sure how much you want to rely on Wong Kim Ark." Translation: your best precedent anchor is pulling you down. Justice Ketanji Brown Jackson cut through the constitutional theory entirely. "Is this happening in the delivery room?" she asked. "Who checks immigration status before a birth certificate is issued? Does a nurse become a citizenship adjudicator?" Even the justices most likely to be sympathetic seemed uncomfortable. One possible ally, Justice Clarence Thomas, who pressed on how much the original 1868 debates actually addressed immigration. But one justice is not a majority. Trump left after Sauer's presentation. He didn't stay for the challengers. He was already posting before the other side finished arguing. "We are the only country in the world stupid enough to allow birthright citizenship." While Sauer had just spent an hour in the precise, careful language of constitutional doctrine, his client was back to the language of the campaign rally. If you're finding this useful, subscribe. I put out videos like this every week, and the next piece is the one I've been building toward. Okay, remember how I said the third piece was bigger than the legal argument? Here it is. The day before the April 1st argument, Pew Research released new numbers. About 9% of all US births in 2023 were to mothers who were either unauthorized immigrants or temporary legal immigrants. Roughly 1 in 11 births. The Migration Policy Institute projected that if Sauer's argument prevailed, approximately 255,000 babies per year would begin life without US citizenship. By 2045, that adds 2.7 million people to the unauthorized population. By 2075, 5.4 million. Not people who crossed a border, people who were born here. Think about that. A baby born in Florida to parents from Colombia and Argentina. A birth certificate. A Social Security number that the Social Security Administration had been issuing for US-born children since 1979. Under Trump's order, none of it would be enough. And here's the piece that gets almost no attention. Statelessness compounds across generations. A child born without citizenship who later has a child in the United States. What is that child? You're not just creating one class of non-citizen births. You're potentially writing a permanent, multi-generational underclass into American demography. People born in America, not of America, in any legal sense. That one shift, 5 words read differently, could produce consequences that outlast everyone in that courtroom. The ruling is expected by late June or early July 2026. When it comes, it will either confirm what American law has held since 1898, or say something no court has said in 128 years. And John Sauer, standing at that lectern on April Fool's Day, carrying an argument every lower court had rejected, with the president at his back and 9 justices watching his face, will have been the man who asked the question. The marble chamber goes quiet when an argument ends. The justices file out. The gallery empties. What's left is the record, the words, the questions, the silences, and an open question about what being born in America is still worth. If this one stayed with you, share it with someone who needs to hear it, and subscribe so you don't miss the next one. The answer is coming, and when it does, we'll be here.